Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Séverine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law.
Welcome, dear listener. This is another podcast in our series. This one is Times Travel Limited and Pakistan International Airways Corporation. Another one where the Supreme Court has been rather busy, I think, rather preoccupied with contract law recently. So here's another one. This is a sad story of monopoly power, I suppose, as a short introduction. And the legal topic is that of economic duress, which is quite a difficult topic. But anyway, if I start with the key facts and the decision and a little bit of the reasoning, then I will ask my esteemed colleagues here, so Dr. Tim and Dr. Severine, for their views about things. So anyway, the basic facts are these. Pakistan Airways have been in dispute with Times Travel as to commission earned by Times Travel on the sales of airline tickets. And I said a few minutes ago, it's a sad story of monopoly power. Well, effectively, Pakistan International Airways had the sort of monopoly control over the flights that Times Travel were able to sell into Pakistan. And Pakistan Airways gave Times Travel an ultimatum. So accept reduced ticket allocation, actually quite a savage reduction, from 300 down to 60 for a fortnightly period, and waive, that is, give up any claims for alleged unpaid commission, or have no further tickets at all. And there was some indication that the ticket allocation would increase if they caved in, basically. And Pakistan Airways believed, apparently, that it was not liable to the commission that Times Travel were claiming. So this looked like hard-nosed commercial negotiation and use of monopoly position. And I suppose the subtext is this abuse of monopoly position, but using the guise or dressing, if you like, of economic duress. And here's a little bit of law coming now. For economic duress, you need 3 things. An illegitimate threat. So this is the question, what is legitimate and what is illegitimate? Plus a causational linkage, not difficult in this case. In other words, Times Travel did respond purely because of the threat. And then the third one is no reasonable alternative but to agree. And that also was quite easy to show, I think, for Times Travel. So all of this dispute really centred on, was this an illegitimate threat? And the decision was unanimous in the end. That is, no duress, contract not voidable, contract good. The pressure applied was part of the rough and tumble, one could say that, of commercial life, rather a hard-nosed approach. So I might describe this myself as this is a hawkish approach rather than a dove-like approach. And Lord Hodge spoke for the majority, so give a nod to the others. That's Lords Reid, Lloyd Jones and Kitchen. They all agreed with Lord Hodge. And Lord Burrows is a bit interesting, A, because he's an academic by background, but B, because he took a different view. And you may, listener, make some assumptions about the different view, possibly because of his background. I don't know. But anyway, that's a thought I just throw out. So the key points were the Supreme Court, by majority, confirmed the existence of the doctrine of lawful act duress. That is to say, it can be duress to make the contract voidable, even though what you are threatening to do is lawful in the sense of within your strict legal rights. And English law, this will upset Severine now, does not have a general principle of good faith. It does respond to bad faith, but it's not very responsive to good faith, if that makes any sense at all. And then the second point is, that said, it's unlikely or unusual, or it's going to be the rare case where you can make lawful act duress stick as a claim. And you can see, if you look back over the facts of the Times Travel one, Times Travel failed there. So it's going to be a pretty radical or extreme instance of where this is economic duress, although what you are threatening to do is within your legal rights. And the way in which, interestingly, the majority get to this is to say, well, the test, if you like, of what is illegitimate, we're going to apply the test that equity law rather than the common law has traditionally sort of used to police, if I can say this, bad faith in a very general sense. And it's that very strange word, unconscionability, or what is unconscionable. So this is an ancient word, really. I think it goes back to the 15th, 16th century. It is about the lack of conscience. So I guess it's the nearest you can say that the law gets to a sort of morality test in terms of, as opposed to a legal test, as to how people are behaving. And normally the common law is about strict rights and what you're legally entitled to do. But equity softens that, or is more sophisticated, depending on your viewpoint, and will police what it would call unconscionable behaviour. So the focus will be on the nature of the threat and its justification. And it's going to be quite a rare instance for unconscionability to be engaged in the realm of economic duress. But as a matter of principle, it's there. Now, Lord Burrows would say, same result. He doesn't disagree with the outcome, but his reasoning and the steps to get to that was, I think, in fairness, Severine might disagree, Tim might disagree with me, but I think quite different. So he has this concept of bad faith, but not stressed, he stressed it quite clearly, not as the European concept would know it, but a very specific, quite narrow concept of bad faith. That is knowingly not believing in the rightness of what you're doing. So that's going to be, if we apply Lord Burrows' test, an entirely subjective test, pretty difficult to prove in practice, and actually very narrow. And I don't know what my colleagues think about this, but I would say it doesn't really stand happily with existing common law approach. That is this idea of not genuinely believing something is not commonly articulated in other rules and principles of English common law, at least in contract law. So it's sort of striking in its, perhaps I might say, originality. So that's the sort of background. We could say much more about the comparative position, for example. It's not just England that is struggling with this. If you look at the judgment, other countries are struggling with this. So, for example, there was a note given to Australia. Any listener there from Australia? It's not entirely clear what the Australian position would be, for example. It's not entirely clear that Australia recognises lawful act duress, seemingly not in New South Wales, for example. It is recognised apparently in New Zealand and in Canada, but the decisions there seem to be quite low level in terms of the hierarchy of their court system. In the US, they do adopt this concept of good faith. And I guess that Severine would say it's not a problem for the continent either because of the general principle of good faith. So now finally with that, I get to some questions. So throw it out to my colleagues. Are you with Lord Hodge et al., the majority, if you like, the tyranny of the majority? Or are you supportive of Lord Burrows? And I guess I'm thinking that Tim, being a quiet fan, say it very quietly, but a quiet fan of Lord Burrows would say, yes, Lord Burrows has got it right. What do you think?
I think you're quite right that I am a quiet fan. I'm not quite sure why I'm quiet on that, actually.
There's no need to be, is there? There's no need to be.
Exactly. There's no real need. If anything in this podcast, I think we've made it quite clear where our alliances lie. But the amount of references to good faith and bad faith, I'm not quite sure what I'm doing in this podcast, because I get the feeling this is going to be a purely
you mean podcast. I can't knock you off the fence.
Yeah.
You're still sitting on the fence here. Come
so
along.
I'm going to hand over straight away to Séverine to get this off her chest. honest. But you are quite right. I'm a little on the fence, although I must admit, I mean, we have to say, Andrew Burrows makes a very convincing argument, I think. What I did find interesting with the reference to other jurisdictions was, of course, Andrew Burrows has written a paper on the lack of comparative analysis in the Supreme Court. And it's quite telling then that the Supreme Court, and not really Andy Burrows, go ahead and then do a comparative piece. So I think that in itself is telling, but that's just a side note. Séverine, I will hand over to you with what you think on whether you agree with Andy or not.
What I find interesting in this decision is that both sides, so of course, Lord Hodge et al., as you mentioned, Maggie, start first, and then it's Lord Burrows. So having looked at it chronologically, not peeked at what Lord Burrows for a while, I thought, Lord Burrows is bound to be disagreeing and coming up with a different decision. So I was quite surprised that actually they agree that there is no duress, and both sides, so to speak, go into great length on explaining where they agree and where they have considerable ground. So Maggie and I, having talked briefly about it before this podcast, waiting for him, I can see my first reaction was, they agree so much. I'm not entirely sure I see the distinction, but being guided by Maggie as ever, it's true that Lord Burrows is quite a bit narrower and therefore probably that surprised me actually, looking at his argumentation. So both agree that indeed, as you said, Maggie, there needs to be, and there is indeed, but the element of what amounts to an illegitimate pressure. So I guess having now considered these, perhaps Lord Burrows' subjective approach is much more difficult to establish and therefore perhaps more conservative than I would have thought would be the case. So it's based on the threatening party creates or increases the vulnerability demand, which is made in bad faith, that no genuine belief that it has a right. Quite a conservative.
But how the heck are you going to prove that?
Well, that's the difficulty that I have with Burrows, because they go on. So what I find interesting in the decision is that both the Lord Hodge and Lord Burrows go on about the fact that there is the law should not effectively interfere, that the law is not here for telling us what is socially or morally acceptable, and that as long as you're not doing anything that is against competition law, then it's okay. And I have a trouble with that, because then they use Lord Stein's expectations of honest men, and then they go on about there is a little bit yes, so we don't have good faith, because of course good faith is this dreadful thing that gives judges too much discretion. But is that not, the courts do make judgment as to what is socially and morally, maybe not morally, but by looking at, the justification of honest men, and I think that is the reasonable expectation. Therefore, it is what is socially acceptable in commerce. So I don't quite understand why they are so frightened of making a judgment that is socially acceptable, because I think in a way that is exactly what it is. When looking at interpretation, they refer to common sense, whether by reference to what is happening on the trade, in a particular trade, in a particular commercial community. All these are completely objective standards, and so therefore it is absolutely clear that there are certain behavior which are socially, in terms of economic behavior, which are not acceptable. So,
well, can I jump in there and say, well, perhaps they would respond and say, well, we are aware of that, and that has been an issue in our reasoning, because we haven't ruled out the possibility of lawful act, economic duress. It is part of English law. And that is a very low level, but nevertheless, some policing of commercial behaviour. And what you're suggesting should be in place is something more interventionalist than that still. And that's possibly the sticking point for a traditional court like the Supreme Court.
I don't know whether that is a sticking point, but it seems to me that what they are saying, we don't want to do it, and yet we are doing it, but because we don't want to be seen to be doing it, we're not going to do it, if you know what I mean.
No, it's a case of never say never.
Well, clear, yeah.
All right? So never rule out the possibility of lawful act economic duress, because the circumstances may be so extreme and morally, I would use that word pointedly now, commercially unacceptable, lying, for example, forging documents, for example. That would be extreme behaviour that ought to be policed by the law. And I think the majority are recognising that the law would become in disrepute and people would lose faith in the common law if there was no possibility of lawful act economic duress making that contract voidable and of no effect. So the fact that they have said never say never, I think is a recognition of the social pressures.
But I think it seems to me that they have agreed that the lawful act of duress exists because precedent tells us that it exists.
Well, it's a bit wobbly though, isn't it? We don't really have really clear law on it. That's why it's gone to the Supreme Court on this one. I think the closest one to it would have been Lord Hoffman in CTN, but from memory that wasn't Supreme Court House of Lords. That was a lower level. So that's why it's needed to have gone to the Supreme Court.
Yeah, but if we compare it to the CTN,
yeah,
what is added? What does the Supreme Court tell us that we didn't know before?
Well, I suppose I would say to that is that there has been a very elegant and neat way of reasoning this through. And I think that is the most interesting part about it, to my mind anyway, is a sort of historical approach, because what this quite conservative group of law lords has said is this would be a very good example for the need of the common law thread, if I put it that way, and the equity thread of law to really be entwined closely together. So you no longer see the different colours from those different branches of law. You know, it's taken 150 years plus, really, this idea of the fusion of equity and the fusion with the common law. Actually, what Lord Hodge is doing now, very elegantly, I would suggest, is to say almost explicitly, the common law learns from equity.
Yes, I would agree with that.
And we are now taking on the terminology of equity and the approach of equity. And duress, if you think about it, is almost like, not the mirror image, but a sort of related sibling to undue influence.
Yes.
And students often have difficulty with this because undue influence is a separate body of law which has been developed from the 15th century, effectively, by the courts of equity. Whereas duress, quite separately, historically, has been developed through the common law courts. And never the twain shall meet, as it were, until we get to 1873, 1875, and this concept of the law saying this is crazy, that we have some courts for historical reason dealing with equity and other courts dealing with the common law. And they sort of jar against one another. Now is the time, that's what they said in the Victorian era in 1873, now is the time to abandon that separation, as it were, and to fuse the two branches of law together. So I think this is a very elegant way of doing it. 150 years too late, possibly, but, you know, we're doing it. We learn all the time. And he's trying to say, I think, to us, the common law constantly learns from equity, and I suppose vice versa. But in an area like this, a topic like this, where you're talking about policing good and bad behaviour, that's traditionally not really the comfort zone, if I can put it that way, of the common law. It is entirely the comfort zone of equity. So naturally here, the common law has much to learn from equity in this little tiny bit of this tiny corner of problems, as it were. And so he's saying, let's take root and branch, effectively, the approach that equity would take here. And so I see that as terribly elegant and neat and also logical. Just have these concepts of unconscionability, which are not novel, not new, but just not really the common phraseology used for the common law. Tim, you've been very quiet.
Well, let me. Yeah, exactly. I've just noticed I've gone very quiet.
You've got to come off.
I need to have a view. Come on then. Well, I think. Go on then. I'll jump off, and I won't tell you which direction.
I'm going to push you if you don't do it.
So, Séverine, you said, what have we learned from this? I think one thing that we have learned, and definitely from Bo's argument, as it were, is where the line is in relation to CTA and cash and carry. In other words, he says quite clearly that had they done so in bad faith, had they made the threat in bad faith, then that would have been the line which, that's where we cross the line. So yes. I think...
but his concept of bad faith, do you mean? This genuinely not believing in your right,
the subjective test. And I'll come on to that because I don't have as much issue with that subjective test, at least taken together with Hugh Beale's test, as it were, when he talks about the demand being coupled with what goes substantially beyond normal and legitimate commercial operations. I think if we couple it with
what the hell does that mean?
Well, it's a test that, and I think Burroughs actually makes this is not new. This is not a test that we have difficulties with, right? In MacDesi, we make exactly that test. Well, we could refine that quite nicely to say, it's disproportionate, for example. And disproportionality is not hard for us to test because, as I just said, we do that in MacDesi.
Yeah, but he disagrees. No.
Yes, but the Supreme Court doesn't like that, do they, really? That was possible. They've rode back a wee bit from.
They have, yes. They
really it's a bit too woolly for them. I think the current.
It's a bit too good faith.
It's a bit too uncertain and unpredictable.
I think Burroughs does say that.
Well, that is the shocking point about this judgment is just how much we hear about certainty.
Yeah.
Right, certainty is the key thread through the argument on this one. It's a real, but actually not surprising when we look at the composition of the Supreme Court here. We are looking at commercial lawyers on the certainty point. Right. I think so. That to me isn't much of a surprise. But I don't have as much of a. I mean, I have an issue with the subjective test itself. Why it has to be subjective when we get to the justification, and I think this might be a point, Maggie, you're going to pick up later, so I'll just brush over it quickly. I mean, generally we use a subjective approach when it comes to fraud, for example, as well, right? We have that high bar in those kind of cases, but I'm not sure it's really necessary because ultimately we're talking about here behaviour that is being influenced by other objective behaviour, a threat. That they couldn't help. Now, what I do have a difficulty with in this case is the idea of the monopoly. I don't think this is actually a monopoly case because after a while we're getting ridiculous on the idea of monopoly, right? Yes, there is only one person who provides milk to me on a Sunday morning at 8:00 in my area. That doesn't make it a monopoly, right? Because I could have my milk delivered at 11 on a Sunday. And it doesn't mean, yes, they built their whole business model here on this, but the monopoly that they were the only ones selling direct flight tickets to Pakistan is such a narrow niche area that doesn't really make it, in my mind, a monopoly. It's not the only way to get to Pakistan, right? It would just not be a direct flight. So I have a real issue here with calling this an actual monopoly. I don't think that the judgment is hanging anything on that word, is it? It's not really. They're not getting keeps coming into what a monopoly is. So to an economics student, a monopoly, I think, from memory, would be 25% of the market. Yeah. But that's a sort of economic definition. But it doesn't fall at all into any of the reasoning here, though, does it? No, but all the judges have accept as given that this is a monopoly situation which should be regulated by Parliament. Well, I think every single, both Burrow and Hodge say that in their judgment, is that we're not going to regulate monopolies
I suppose
here.
as Severine is saying that anti-competitive behaviour is the sort of thing that ought to only be policed by Parliament. It's not appropriate for judges. They don't have the resources and the research capability in terms of judging any of that. That's entirely appropriate for the legislature.
I think they use that because you're right, Tim. Both sides, even though they are on the same side, like both the majority and the pretend minority. Let's say that. I mean, I read something quite interesting that. There was a comment by a law firm saying that Lord Hodge, the way he wrote his judgment, was probably because he expected to be part of the majority. It is a lot more detailed and argued, but yeah, I don't know whether we can say that. But I think both
well,
sides.
What they do quite commonly, don't they, in terms of practice, is to circulate drafts. So he may have prepared a draft speech and circulated it to the others on the panel, and in that way they get natural agreement or identifying where they don't agree.
Yes, yeah. I can see that. Otherwise, they have a look at each other. Otherwise, they wouldn't say, so Lord Burrows says this and I disagree and whatever. But I think what I sense here is that even though. So it's almost a reiteration of what English law principles are all about. I can definitely see a stance on we don't need this woolly thing of good faith and that doesn't help. English law should not interfere with parties' business. And so I think that's why they make the reference to as long as it is okay with competition law, and both Burrows and Hodge refer to the same academics and refer to the same cases to show that actually what is morally or reprehensible has nothing to do. And, so therefore English law is about certainty. And I wonder whether this is a reaction to some of the decisions that we have seen about relational contract and the call for more flexibility and the call for more cooperation. I don't know whether that is the case, but I think the one, perhaps I wonder whether, Tim, you meant about, disagreeing that it is a monopoly. It is absolutely clear that in terms of size, TT was much smaller than PISU. So I think in that sense, and I think perhaps they, all of them go into, especially Lord Hodge actually, saying that yes, they were of different sizes, but in the cases that they've used, they also made the point that actually just because you are big doesn't necessarily mean that this necessarily gives you an advantage. I think they were talking about the Australian case about that the minority shareholders.
But it's not just about size, is it? So the background here is about dependency. I know, that's why. Times Travel were entirely dependent on Pakistan Airways, effectively under their own created business model.
Yeah. Arguably, yes, that, they solely relied on them, but in a way, when you have 300 commission, I can't remember, was it every 2 weeks? So I think, that in a way they didn't need anything else. They might have been smaller, but they were very profitable. And maybe that was the source of it. Suddenly we thought, oh my goodness, we're paying so much on commission. But so here, I think it's almost the Supreme Court reasserting itself as what English law principles are all about, and that we are going to only interfere into parties' business on really, really strict and limited background, because both of them, whether they Lord Hodge and Lord Burrows' criteria are slightly different, both of them are quite restrictive. They do say that it's only in extreme circumstances, and it makes me think a little bit of, I know it's a slightly different viewpoint, but it makes me think of what Professor Rowan wrote in relation to an abuse of right, that, she does make the point that there might be a doctrine of right. It's all there, but it's only in limited. So here, again, it's reasserting that the courts are only going to agree on a limited interference with parties' business.
And unequal bargaining position is nowhere near enough to be
enough.
policed
and
by
that,
the law.
Yes, that I have no trouble with. I think it's just the way it's been phrased, whether I completely see the contour and the parameters of what is a lawful act of duress.
I mean, just to jump in there, I think we're all agreed, and I think the Supreme Court is agreed on the inequality of bargaining power has nothing to do with things, and I think that's just, and I don't think that even on the continent that doesn't play a role. It may be a factor in whether they've used good faith or not, but that's I think we're all agreed on that. I think the key point here is the subjective test that Burroughs is bringing in, and whether in itself it has to really be subjective. I mean, one of the difficulties with this subjective test is that I have, at least, is that the other party has no way of influencing that. Right? I can tell the other party as many times as I want, no, you don't have that right. But so long as they subjectively believe it, that's tough.
Yeah, and it's a question of whether they will be believed in that protested belief.
Yes.
You see what I mean by that? If your belief is so ridiculous, and yet you are coming across as otherwise a reasonable, sensible, intelligent person, you run the risk that the court won't believe you when you say you genuinely believed it.
That's a difficult standard.
You see what I mean?
That is really, that would be...
Well, I think that's what happens day to day in courts anyway, when the issue is one of honesty, if you like, or genuineness, belief. It may come to a point when it looks so ridiculous that you are not believed.
So why do we need that standard? Why do we need to? Because as far as I can see, the idea that Burroughs is peddling here is the fact that someone is exploiting the vulnerability of another, maneuvering them into a situation in which they can't do anything else.
Yeah,
that is the
mischief. And genuinely doesn't believe in the rightness of what he or she is doing.
Why does that matter?
I suppose he's using CTN, cash and carry, and what Lord Hoffman said about it was a comment he made, I think, in that case. Severine will know it better than me, but about a finding that the party genuinely believed that they were in the right with making the demands that they were making. They thought the law was on their side, and that was a genuine belief.
Yes.
So Lord Burroughs has picked that up and is running with it now to make that the test, if you like, at the Supreme Court level. So that's where I think it's come from. But apart from that, those comments in CTN, cash and carry, I'm not sure that there is a very solid foundation generally across English contract law for this sort of test. You know, where else is it used? It's used in unilateral mistake. You know, you make a mistake and I know that you have made that mistake. So there's some subjectivity in terms of me then. But
there's an objective addition in there from centre of interest, which is all they ought to have.
Yes, okay, but there is
an objective standard.
All right, but there's a bit of subjectivity in there. So almost really what you're saying to me, Tim, now is indicating what I'm trying to say, in that subjectivity tends not to be an important test for the common law. So to suddenly run with it now with economic duress, it jars a bit. You know, you look at it and you think, well, where the hell's that come from?
Yeah. So I think that's where we've got common ground. So I like the test. I think the test is quite right. And I think when Lord Hodge says, well, okay, it's bad faith is then coming from content and context. So long as we can say that that's an objective standard, I think that's the middle ground. Personally, I think that's the middle ground here. And that's why I'm on the fence. Is that
Well, I suppose Lord Hodge would say this lack of genuine belief would be a factor in deciding whether it's unconscionable. Yeah. But only a factor. whereas Lord Burrows wants it to be root and branch the central test. And that's why Severine was saying half an hour ago that actually Lord Burrows' approach is narrower than the majority. And I think I would agree with her because this lack of honest belief in your own situation and the status of the rights that you're purporting to have would be part of an unconscionability test, but not the end of the test.
But perhaps where the objectivity comes in Burrows is when, the element of not the victim, but the other, which name escapes me, threatening the party creates or increases the vulnerability. So that is an objective, but yes, that's one way of looking at it. Yeah. Does it or does it not? It's neither, either they do or they don't. And so therefore here on the fact, it's reasonable, it reasonably is easy to assess, but so that would perhaps be one element where the objectivity can be, or there is an element of
I mean, don't you think it's difficult to nail down a definition of bad faith? Certainly we can have descriptions of bad faith, but I can see the difficulty at Supreme Court level to nail it down suitably, narrowly and precisely as guidance that would cover all events, as it were. That's a real problem, isn't it? They can give examples that they mean forgery, misrepresentation, blackmail, cheating, playing on fears, exploiting fears. Unconscionability is hard to define exhaustively, but in essence, that's the sort of thing that it's kind of like an elephant. You may have difficulty describing it or defining it, but if you see it, you know that it's there.
So both of them go. So I think they do indeed try. What is referred by Lord Burrows as the bad faith demand. Yeah. I think the bad faith demand is a mixture of knowing that that you don't really believe that you have a right to do that, but there is also the notion of opportunistic behavior. And I think that's where what I was saying earlier, that they really are trying to, move away from all these, good faith, etc. Because here they would have had an opportunity to define a bit more what is it that they mean by the bad faith demand. So aside the absence of belief that they have a right to do, I think here it's also coupled with the opportunistic behavior that seemed to be talked about in Bates, in Al Nahyan, and all these cases which were on good faith. That aside,
I thought we might get there.
Yeah, I've got it here. Back to good faith. But so I'm almost amazed that the opportunistic behavior was not defined and talked more, because I think there is an element to it, and both Hodge and Burrows do mention it, but almost to say, okay, we don't need to talk about it. So by the same way they have looked at this notion of legitimate interest and the disproportion, and said that it doesn't help us here, and they've dismissed it. So I think they know, but you are right, Maggie. So that's why it goes back to what I was saying. It's a very traditional decision, going back to commercial certainty. You're right, Tim. I think it would be interesting to do a search on the document to see how many times they do refer to commercial certainty in all these cases, and all these traditionally classical doctrinal theories.
Yes, it is very classical. I think I agree with you, Severine. It's almost Victorian.
Yes,
in its outlook of the free market is is king. Yeah. And to borrow your French again and say it, mangle it, laissez-faire. That is such an important, dominant feature for traditional classical English law, and this is so obviously so here.
Yeah.
And I think the judges even say it almost in those words, which is, yes, they had there was a monopoly position, but if they didn't want that, They should have put it in the contract,
Yeah.
which is one of the oldest sentences. I think Hugh Beale references this fairly often as being one of the most traditional English positions, which is, if you didn't want this to happen, well, you could have put it into the contract and you're two commercial parties. Yeah. So in other words, if they wanted more protection, the
answer to that is because of the imbalance in bargaining position, they could have asked, and perhaps they did ask, but they weren't going to get.
No.
Well, in that case, I think the idea is don't build your business model on it, right? Or insure yourself against it in some kind of way.
Well, indeed. And do you not see that there's some sort of analogy going on here with the Marks and Spencers and Baird case?
Yes.
Where you've got a little supplier, Baird's, wholly dependent on M&S to have their regular contracts being placed, and then the plug is pulled and they have literally not a leg to stand on.
I would almost say that Baird was worse in the sense that there were certain expectations that were created by being a supplier of M&S. So I don't think in this case
But not by anything that M&S said or did. That's the problem. The expectations are built on hope. Rather than legal right.
I agree with the second part, rather than legal right, but I think it was an expectation that was generally created, and probably by M&S to a certain extent. But even if it had been, I don't think it would have made any difference. Because there's no contract, there's no...
But as you were saying, to quote Professor Beale, if Baird had wanted something different, they should have asked for something concrete as a contract is what we're talking about as lawyers. And they may have, who knows, they may have asked and M&S told them where to go.
Yeah. I mean, I think we're surprisingly all on the same page here, despite all these references to good faith and bad faith. That's going a little far.
You mean we're in agreement? This is the time to end this podcast, listener, because it's not going to be very interesting if we're in agreement.
The one time in history that this happened.
Quit while you're ahead.
What I find in...
I can't remember, Tim, though. Did you get off the fence? Are you pro Lord Burroughs or Lord?
Well, that's interesting. So I like Lord Burroughs' argument, and I think as such the subjective test isn't something that's radically new in the sense that we use it in other areas, i.e. fraud, for example, right? With requirement a subjective state of mind. I don't see necessarily why we need it. I think this could be done through other objective tests. In other words, could they have known better? Would probably solve that.
So I am much more pro-Hodgian, I suppose. I am Hodgian here, and you two are more Burroughsian.
I'm not sure Severine is. So are you Severine? I thought you were Hodgian.
No, I mean I can't. I think
have I worn you down, Severine?
I understand exactly where their differences lie. The Lord Burroughs is quite beautiful, but yes, I think, by the fact that it is, more subjective and narrower,
yes.
I think I would have to, go with a slightly wider one. And so, but yes.
yes. I've got Severine on side. I can feel it.
The other thing which, I had something, and I've lost the thread of my thought that I wanted to say again. Another reason why it was quite a traditional one. Okay, ignore me, Tim. You will have to.
Oh no, this stays in from now on. We take everything. Everything is published.
Yes, I think the listener rather has managed to work it out by now that there is not a lot of strict editing.
Oh no, we don't. The editing is fairly lax on this podcast.
It's what's called a live event, live TV, live radio.
Isn't it? Isn't it just? Maybe we'll be invited to the BBC at some point with our. I would like to get. So the interesting part I thought was, and that I thought maybe I've missed it in other judgments, but I thought in this one this fairly regular referencing of deliberately creating and increasing a party's vulnerability is it me, or that seems new to me?
Yes.
That's or at least a reference to vulnerability as an idea. Now, I don't want to go off into the topic of vulnerability in itself, but this idea that we're taking that seems to me to be quite a novel addition
I wonder whether this is the part of my argument about the sort of subliminal influence of equity approach.
Oh, so you say, okay, so the translation of equity is now coming into
unconscionable conduct. Yes, because they have taken this concept of unconscionability straight from equity. So I think playing on someone's vulnerability would be something traditionally that equity would have looked at very hard.
But I think where perhaps, they have gone, all of them have gone through quite a wide brush as to where the law does interfere. I think so the word vulnerability in itself is interesting, but I think that was indeed implied into the categories. I think maybe it has not been what Burroughs is doing is putting giving it a name. But I agree with you, Maggie, that whether you were illiterate or, there were certain categories. So where the novelty is to put all those categories into one, and that you are vulnerable in some ways or another. And so, but I don't know whether that is entirely
unconscionability.
Well, for example, what about blackmail? Blackmail to threaten to report someone for a crime is not per se illegal. It's doing it for gain, and that would be a problem under the Theft Act. But that's sort of working on someone's vulnerability because of the weak position. So that's
Burroughs' argument when he talks about it's not so much the threat, but the bad faith nature of the demand. Yeah.
The reason
that's
for
only the
it.
First
Why are you making that threat?
That's only the first part of the test. I mean, the second part is then deliberately creating the vulnerability. So I would have thought that's the new addition. So the blackmailing part would be the bad faith demand, as it were, whereas the vulnerability would be an additional tag on. And also, interestingly,
from memory, if the case that they referred to was Borelli and Ting.
That's right.
Which is a company one and a liquidation situation. So the director there was lying and not helping the liquidator, although he was obliged to do that as a former officer of the company. So I think they'd taken that case as an illustration, possibly,
yes, and I think
of this manoeuvring a party, because he was manoeuvring the liquidator into a corner.
Mm. Yes, and Progress Bulk Carrier, I think, is another one that they, if I remember correctly. But, I mean, so unconscionability, I mean, I've always had a bit of an allergic reaction, I think, to the word unconscionability. It seems to me to be very American.
Lawyer,
exactly.
Not an equity lawyer. An equity lawyer would have no difficulty with this at all. That's because most of contract law is common law, isn't it, Tim? So this jars with you because it's equity. Students who are studying equity would have no difficulty with that word at all. This is the point about these different branches of law.
I take that, yes. Okay. When I think of unconscionability, it's more the American conception of broad, in line with good faith kind of thing. That might be also add to it.
Okay. I don't think we use it
no,
like
exactly.
that.
But the unconscionability always seemed for me to go back to the behaviour rather than the vulnerability of the other party. So it seems to me that the unconscionability aspect is the behaviour rather than the situation of the other.
But the vulnerability, the position of the other party is always going to be relevant.
Absolutely,
yes,
it is.
Because you can't manipulate and abuse someone who's as strong as you, if not stronger. It's sort of what we're looking at is commercial bullying in a sense, isn't it?
Well, yes and no. You can. So that's where I think it is an Australian case. Okay, so only persuasive, but where the court, that's what I was saying earlier, that both have gone into a lot of detail to show that actually the fact that TT was smaller in size in itself is not enough and not arguably relevant. So if you are in a position of strength. You can be in a position of strength from being smaller.
Yes, it's not the size per se.
Size doesn't matter.
Indeed not. I have to say this, I'm only 5'3". How tall are you, Severine?
Oh, I'm 1m63, so I don't know how many.
I was going to say, say it in proper.
How typical, you've done it in the continental measurement.
Still continental measurement. And I don't know what it is in feet.
I think that has to be the title or the description of our show today. I'm definitely getting
matter.
Something. Size doesn't matter. Oh dear. Oh, Maggie.
No, that is a bad one.
Let's not do.
All right, try this. Lovely things come in small packages.
There we go. I think we'll roll with that one. That's our show title for this episode.
Is it time to give up then with this?
Excellent. Well, I don't know. Have we reached a conclusion? Where are we?
I quite like the elegance of Burroughs, but given that it is probably narrower in terms of my leaning onto the role of the law, I think Hodge is probably easier to apply. So by the fact that it is easier to apply,
I will take that as agreement.
But as a typical lawyer answer,
Yes,
I am
Severine.
edging my bed by saying, but
it's a grudging.
I almost need to reread
grudging.
the case to reread the judgment, because there is an awful lot. It is a long judgment from both, and both of them, go into length to say, I agree with you. I think Lord Hodge starts, the first few words is, there is a lot that we have in common, or there is a lot that I agree with. And I think Burroughs probably does the same. Hence, that's what I thought I was looking forward to reading.
Yeah, okay. There are a lot of points of agreement, but a couple of divergent.
And I think I'll say I'm going to remain on the fence a little bit, but definitely leaning on the Burroughs side. As in, I like the test. I think the test is great, and I would just combine it with a tad of more of removing that subjective element, and possibly the combination then of Beale and Burroughs as a test, I think would work perfectly. So we're almost there. He almost got it right.
Okay,
great.
Well, is that the point where we should leave dear listener in peace?
I think so.
So, and we might want to remind our dear listeners, of course, that they can contact us by email with questions, ideas, suggestions, and I can't think of any other words, but you know what I mean, by emailing us at unpacking.contract.
Any case you'd like us to look
Absolutely, yes. Email us at unpacking.contract.law@gmail.com and we'll read it.
Yes.
That's about as far as our promises will go, but we'll read it.
Thank you very much.
Thank you very much.
Thank
Bye.
you. Bye-bye.
Bye.